Good morning, sir. Are you Jason Jones? And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Jones, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. And so, Mr. Jones, in cause number 23, DCCR 0390, I have a motion to revoke your community supervision. Shows that you were placed on probation June 2nd of 2025 for the third-degree felony offense of unlawful possession of a firearm by felon, and that was a 10-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you were arrested for, state wish to do anything with that wording?
I would like to amend it to say.
Y'all gotta go through all
committed
these.
the offense of.
On counts 1 and 2?
Yes, Your Honor.
Any,
I have no objection, but also point out, I assume the date is wrong on number 3.
That's correct. It should read June. Count 3.
This is filed July 30th.
yeah, probably. I'll print it. I need y'all to go through all these motions for the arrested language and change those.
Kelly, do we have an idea when it started?
I'm sorry?
When it started?
She has no
reading the
idea.
rest? Okay.
The MTRPs say arrested for instead of, y'all's people write them, so I don't know when they started doing that, or who, if it changed up there, if
Probably
somebody
because-
changed that did that.
Well, we're third secretary in office.
Okay.
A little over a year, so yeah.
They need to, somebody needs to make it their job to go back through all of them. Maybe at least for that year. It seems like it's been an issue.
I think so.
Okay,
But what I'd like to amend, Your Honor, is take out was arrested for and put committed. So read committed the offense of.
and that's on 1 and 2. Any objection to that change in counts 1 and 2?
No, Your Honor.
And then in count 3,
The date should read June 21st, 2025.
any objection to that amendment? All right, made those changes and grant all that. Okay, so count 1 in the motion alleges that you violated your probation by committing the offense of possession of a controlled substance June 21st of 2025 in Jefferson County, Texas, and is that true or not true? Count 2 alleges that you committed the offense of possession of a controlled substance. So the first one is penalty group 1-1/1B. Count 2 is that you committed the offense of possession of a controlled substance, penalty group 2A. And is that true or not true?
Not sure.
And then count 3 alleges that you possessed a drug, marijuana, synthetic marijuana, and crack cocaine on June 21st of 2025. And is that true or not true?
Not sure.
And then count 4 alleges that you failed to stay away from locations considered high crime areas by being arrested by BPD on June 21st of 2025 in a high drug trafficking area with various illegal substances in your possession. Is that true or not true?
Not sure.
When a probation violation hinges on new criminal allegations, what matters more in court, an arrest or proof that the offense was actually committed?
All right, so what we'll do, I'll enter pleas of not true to counts 1 through 4. We will reset this for a hearing. How long would you anticipate? I'm assuming you'll need lab and,
Judge, the substances have been sent off to an independent lab to expedite testing. It's currently in their possession being tested. I made that request in early December, so I expect it to be back before we have a hearing.
okay, we'll reset it for a hearing. I'll get an updated pre-sentence report. And as soon as obviously you get any of that information, get it to Mr. Parker. We'll set it for maybe a day where we have a little longer than just an 11 o'clock. We'll set it where we have time for officers and whatever we need. Okay?
Thank you.
All right, you can go back with the bailiff.
This exchange illustrates a structural safeguard within probation law. Revocation cannot rest on accusation alone. The court required amendments, corrected language, and deferred judgment until evidence could be tested. In doing so, it reinforced a central principle of criminal governance. Liberty may be restricted, but only through proof, not presumption.